Hello, am I audible to you?
Good morning. Yes, I can hear you.
Okay. Just give me a second so I can share my screen with you.
It's okay.
Can you see the screen now?
Not yet.
Okay, give me a second. Now is it visible to you?
Yes, it's fine.
Okay. So basically, I hope you're doing good. My name is Ramika Verma and I'm here to teach you the subject business law. Okay, it will be divided into six blocks which we will cover up in uh, around eight lectures. So today is our first lecture and we will start with our first unit, which is called as essentials of a contract. First of all, if I just talk about the subject, which is I told you about business law. So, can you please explain me what you understand from business and law?
Can I speak, madam?
You are not audible actually. Can you please check your mic?
Okay. So,
Yeah.
uh, for me, business is each activity that generates resources or additional resources after an investment. And law is the general regulation of this activity.
Okay. So basically, in if I just talk about in general, business law contains two terms. One is business and one is law. Business we all about in general, if I just say selling and buying, we can say that is business in a normal language. But overall, if we checked it out, business is a very wider term which we cannot sum up in just a one line. So business law means we need to do business with certain terms and conditions which told us by our government or some acts which are made by our government. So, first topic for that is essentials of a contract, for in which first topic is introduction. If we talk about business law is essential because we are doing business for society and society needs law. And to do business, selling, buying, trading, we just need to be in a certain law which we cannot change according to our terms and condition. We need to follow from our government terms and condition. So if you want to do business in a particular country, there are certain norms. Like India contains certain norms, US contains certain norms, UK contains certain norms. So you just need to follow these things because you are doing business for society, not for yourself. If we talk in a traditional way, in the traditional time, we can say that we are doing business for ourselves. But in the modern sense, consumer is our king, and consumer is our king. So we are doing business for them, not for us. By doing better things for them, we are having profits, and from that we can say that we are doing business for profit. But our main agenda is to welfare of society. So, if we talk about the introduction for business law is just a thing which we need for society selling and buy for day to day personal dealings. So, we can earn from it and we can survive our own things. If we talk about law, what is law? Law is necessary for all of us in our society. We need to be in law. We need to follow certain terms and conditions, certain rules, certain regulations, which are told us by our government in the form of act, in the form of it's like there is certain law like company law, sale of goods act. These kind of laws are generated so we can talk about them, follow them, and we can run our business smoothly. So, if we talk about the definition given by different authors to us, law, what is law? If I told you in in a layman language, I can say that law means a set of rules. What kind of rules? Which are covered civil conduct. If I just talk about the civil conduct, who govern that? Supreme Court govern that. State govern that. Our government govern that. If we are doing anything wrong, which is against our rights, which are against our law, so we cannot able to survive. So for that thing, we just need to do right things according to law, which are given in the civil conduct. If we talk about the definition states that law is a body of principle recognized and applied by the state in the administration of justice. That means क्या basically हमें what we need to follow? We need to follow principles, set of rules and regulations to fulfill our requirements. If we talk about the business law, what business law means to us? Business law means we need to follow our business rules which are told us by our law. Law can be of different type. We can run our business from experience. We run our business from certain case studies. We run our business from our own mind. We run in a multiple way. Business is a thing which we need so much experience to fulfill it, and to each and every day we are just doing exploring it our business. The first thing, if I just told you about the business law, is English mercantile law. If I just told you English mercantile law, as we all know that our law is kind of some topics are taken from the English law, which is from England. So basically, English mercantile law states that there are so many customs follow in our culture. We need to take care of that. If we cannot able to take care of our customs, our traditions, so we are not able to do business. It's like there are so many cultures in our country. If I just talk about India, if I am said to you that we are doing business in India, so I need to follow so many cultures. Which kind of cultures? There are different religions like Hindu, Muslim, Sikh, Christian. There are so many religions. I need to fulfill their demands because I am doing business for them. I am not doing business for myself. So all the customs and usages I need to follow for my customers, not only for myself. If I talk about second thing, Indian statute law. If I talk about Indian statute law, Indian statutory law contains that business law which contains so many acts, because business, I told you before, business is such a wider term. If I just sum up in one line, that's not possible for the business. So there are certain acts maintained by our government so that we can understand all the things step by step. Like, first thing, what is Indian Contract Act, which when it will establish 1872, Negotiable Instrument Act 1881, Sale of Goods Act 1930, Indian Partnership Act 1932, Companies Act, which is recently changed in 2013, Consumer Protection Act, Security and Exchange Board of India. These kind of acts contains so many rules, so many regulation, which I need to fulfill according to my business. What my business needs, what my consumer needs. So I'll do all kind of rules and regulation and told to them and follow them, so I can run my business in a better way. Third thing is judicial decisions, or I can say that case law. What is judicial decisions? I must say, business is all about experience. First, I need to study cases which there are, I can say that in the past they happened. So I need to study them, then I apply them in my business, and then I can go further. Means, if I just said that today I am facing some kind of problem, to whom I ask? I just go to my parents and I ask them, what can I do in this situation? They told me suggestion according to their experience. What is that thing? That is case study. If I just told you, you are doing business and you are facing some kind of trouble, there are lots of case studies given to you. You can study that thing and you can follow that thing and apply in your business. It might be possible your problems will rectify. Third thing is custom and usages. Sorry, fourth term is custom and usages. What is custom and usages? Basically, I told you there are so many religious kind of things, so many customs are gonna follow, so many trade customs are gonna follow. Means you are doing business on credit, you are doing business, which kind of relationship you are maintaining. So these kind of things are considered in custom and usages. These things you need to follow. If you follow these rules, these kind of yeah, I mean to say, it's like today we are doing business with full of marketing. What is marketing? We are doing marketing for to grow our business. That is known as business nowadays. If you are doing good marketing, there are so many customers of you. If you are not doing any kind of marketing, there is no customer for you. So you just need to follow these four things. One is English mercantile law, second is Indian statute law, judicial decisions, and custom usages. Next term is the law of contract. What is the law of contract? Law of contract is the most important part for business law if we talk about India. Why? Because there are so many things. If you are doing a business, first you need to contract with the person. You need to if I just told you, we listen every day that there is this kind of contract, this company signed this contract with this person, this company signed this contract with this company. So there are, each and everything is based on which thing? Contract. So first we need to understand what is contract, what is law for contract. So to understand that thing, we just maintain a act, whole act, which is known as Indian Contract Act, which is established in 1872. That means we are doing business from that old. Nowadays we are doing so many things, so many businesses, but we need to follow what Contract Act, Indian Contract Act 1872. Further that there are so many variations come in according to these act, because you know like there is a change in everything. So if when we are doing business we just follow so many things, we just if I can give you example for this, we are modernizing each and day, we are changing our technology, we are changing each and everything. So like that we are changing our contract system also. So for that we consider more acts for this, like sale of goods act, bailment, indemnity guarantee agency. There are so many terms in it which we read in the further topics. Next point is, what is contract? If you want to understand contract, first you need to understand the meaning of agreement. If I'm not wrong, you are aware of these two words, contract and agreement. Yes or no?
Yes.
Okay, what is agreement? Do you know any kind of difference between contract and agreement?
I think that the agreement is the content, and that the contract is the is the format in which we have to contain the agreement.
Okay. There is a minor difference between agreement and contract. Uh, if I say that each and every contract is an agreement, but each and every agreement is not a contract. Okay, means if I am considering a contract, that means before that it is an agreement. But if I am saying that there is an agreement, it is not necessary that there is a contract also, because contract uh, enables a function also which is known as enforceable by law. Each and every contract has this consideration that it has to be follow all set of rules governing by our government. That's why it is enforceable by law. If I just say that by giving you example like that, that if today there is a rain, then I'll give you, just give me a second please. Yeah, if I'm giving you example for this, if I'm saying to you that if there is a rain, then I'll give you some kind of amount. If there is no rain, I'm not going to give you any kind of amount. It's just an agreement, I am just saying it. Okay, it might be possible, it might be not possible, and it can be illegal and it can be lawful also. If it is lawful, then it will be converted into a contract, but if it unlawful, it will never be converted into a contract. Okay, so what is contract? If I just say it to you, a contract is an agreement creating, defining the obligation between parties. Contract is a I sorry, agreement is a part of contract, but contract is not a part of agreement. Every agreement and promise enforceable at law is a contract, which I told you before. Each and every agreement, if it is enforceable by law, that will be a contract. Means you just need to remember two things. If if you are considering a contract, there are two elements. One is agreement, and second one, it is enforceable by law. There is no third term for it. You just need to follow these two things. Now, if I talked about you agreement, first thing is that agreement covers section 2E of Contract Act. What Contract Act? Contract Act 1872. You just need to remember that thing. And you just also need to remember these sections also, which terms covers under which section for your exam point of view. So they give us a equation also for the agreement. Agreement is equal to offer plus acceptance. You just need to follow two terms. First, you just need to remember. First, you just need to remember contract. Contract parts. There is a agreement. Agreement parts. There is a offer and acceptance. Okay. Is there any
Okay.
query?
No, it's clear.
Okay. So if I just talk about you, offer and acceptance. So I need to offer something to somebody, and somebody needs to accept that thing. That becomes agreement. Okay. If I want to do a agreement with you, so I just need to offer you something. Then it is necessary you need to accept that thing. Then it is necessary that it will be lawful. Then it became a contract. Okay. First I need to offer you, second thing you need to accept it, that becomes agreement, and if it is lawful I am talking about, then it become contract.
Okay, okay.
Okay. There are some kind of legal obligations also. What kind of legal obligations? If I just said it to you, legal obligations, there are so many legal obligations you need to follow when you are doing a business. Each and everything to be legalized. Like there are so many loopholes, so many businessmen consider it, so many businessmen use it in a negative way. They earn money, then they just escape. There are so many losses for people. So you just need to understand legal obligation. What is legal obligation? Whatever rules, whatever duty, whatever things our government, our set of rules given to do a business, we just need to follow that. If we are following that, so that means we are fulfilling our all legal obligations. For that we can appoint so many, if I just talk about so many MNCs nowadays, they just offers jobs to a lawyer also in their MNC to fulfill all legal obligation. There is a whole firm, law firm, they appoint big MNCs. If you are talking about small firms and small businesses, they cannot afford these kind of MNCs, so they just stick to the basic principles, which is legal, which is illegal. They just follow those rules and continue their business. But if I just talk about big MNCs, you are doing business on a big scale, so you just need to do, you can appoint all business sorry law firm, or any person who is qualified from law, or you can appoint company secretary also, who deal with the all company law. There then they give us a difference between agreement and a contract, which I told you before. You just need to remember that thing, that if there is an offer and acceptance, that will become agreement. And if that agreement is legal, you fulfill all kind of legal obligations, then it become your contract. Then there is a classification of contract. We just, there are three main headings they given us. On the basis of creation, what we create; on the basis of execution; on the basis of enforceability. First we talk about the on the basis of creation. If I just talk about creation, that means something we are creating from it. So there are two kind of contract. One is express and one is implied. Express thing we can express by saying things, or we can express by in a written way. We can express oral or written in both the ways. That is known as express contract. Means I am just telling you something, you are agreeing on it, and that is legal, and we are agreed to doing something for our business. That is express contract. I am expressing something to you, you are expressing something to me, whether it can be, whether it can be oral or written. That is known as express contract. Second thing comes with implied contract. Implied contract is a contract for which there is no words, there is no written thing. That means that is not oral, that is not written, but that is implied to you. That means you know it, you need to do that, and I know it, I need to do that. Means it's like today, you pay for your subject. Okay, you took admission, you pay for your subject, it is implied with that education institution, they are giving you classes, and it's implied to you that you are taking classes because you pay for it. It's also a kind of contract. When you took admission somewhere in some institution, that means you are that institution is doing a business with you in a certain way. So you pay for your classes, so it is implied for you that you need to attend that. That is called implied contract. If you are going in a shop, you are purchasing something, it's implied to you that you need to pay for it, and you have to pay for it. Nobody is saying anything to you, and nothing is free for you, because everyone is doing a business there. So that is implied contract, which is not saying by words, or which is not in written. But express contract is always expressed word. What is you can understand from the word also, that you if something is expressing to you. So that means that is express contract and implied contract, which you just need to understand. Then there is also a term which is known as quasi contract, which comes under the section 68 to 72. Now, what is quasi contract? It is a part of implied contract. Implied contract means you need to you are already know that you need to do something. You need to do some kind of business. You are doing it. Quasi contract is a contract which it is kind of contract, but which you cannot be perform at the same time. Means you need to perform by operation, by certain law. Means if you purchase something from a shop, by mistaken he gave you two extra things, you just go to your home, you use that things. But if that shopkeeper blames you that you did not return that thing, and you know it very well that he gave you by mistaken, and he files a case against you, so you just need to pay for that two things. And it is not considered as by mistaken, but you consume it, and you know it that it is wrong, but still you consume it, then you just need to pay for it. So that is called quasi contract, which is operation by law. That means third party involved, somebody filed case on someone else that something is not gonna happen, that's why you need to pay for it, for any kind of wrong, or if you did not follow any kind of rules or obligations. If I just told you sorry, next point is on the basis of execution. Executions, obviously word we all listen every time. What is execution? Can anybody tell me?
I think that execution is the implementation or the way in which we apply the contract.
Right. Execution is the thing when we apply something, when we are doing something. So there are two terms they define the in this heading: executed contract and executory contract. What is executed contract? Executed contract means miss. If I am giving you example like Mr. Sorry, let it be for this Mr. A. Let if you just assume that you just go to a shop, you buy something, you pay there, you just take that stuff, and you came back home and use that stuff. That is executed contract. That means which both the parties are present, both the parties know their work, both the parties perform their thing, and they just set off. That is known as executed contract. That means which is already executed, which is already implemented. That is executed contract. Executory contract is the contract when parties need to perform it, but still he or her not performed present. Okay, means I need to perform something. I contracted with you and I need to perform, and you are waiting that I am, if when I perform, then you reciprocate. But I am not performing it still now. That means I am not executing the contract. So it become executory contract. Means two parties have to perform something, but they are not performed still yet. Okay, they will perform in future. That is called executory contract. In simple words, if you need to understand, executed contract always be in present, executory contract always be in future, or one of the party needs to perform it, but till now he or her is not performed it. Okay, that is executory contract. Next, on the basis of enforceability. Have you ever heard enforceability word?
Yes.
Can you explain me?
I'm understanding enforceability is the manner or the measures taken uh, to be ensured that the contract is followed.
Okay. Enforceability, basically, if I talked about this term, it is related with the law. When I use this term enforceability, that means my contract need to be enforceable by law according to this act. Okay, I am not saying this term always use each and everywhere with the same meaning, because there are so many different meaning from one word also. So basically, if I am enforceability talking about here, means I need to enforceable my contract according to law. That is enforceability. So first point, if I talked under sorry, enforceability, that is valid contract. What is valid contract for me? Valid contract for me is, first somebody needs to offer me something, then I need to accept it, and it has to be lawful with some kind of consideration and enforceable by law. That is valid contract for me, in a simple way. If there is any kind of thing that my contract is not going to be performed, or any kind of thing that it will become illegal, or any kind of thing ki, it cannot be happened in future, it cannot be performed, so that cannot be considered as a valid contract. Valid contract needs to be offer, acceptance, agreement, plus enforceable by law. These are the key features for a valid contract. Second thing is void contract. This may be a new word for you. Void contract. Void contract comes under section 2J. That means I can say that when I start doing contract, or when I offer something to somebody for my contract, and there is an agreement for that contract, and that time it is legal. But when I need to perform it, it become illegal or impossible to perform that contract, that so that it become void contract. If I am giving you example for this, I can say that Mr. A did contract with Mr. B. Okay, they need to perform some kind of contract, like Mr. A is selling his house to Mr. B. But before doing that contract, Mr. A expires, and there is no legal hires present to perform his contract. So it becomes void. Or I can say that it's like there is a thing happened in India, which when they just banned 1,500 rupees note. Okay, if I was doing business that time, and I contracted with someone, and in that contract there is a condition that I am gonna pay with the whatever amount it is, but with the multiple notes of rupees 1,500, 100, but still my government banned that thing, that you are not going to use 1500 rupee note, so that becomes void contract for me, because one thing I cannot be able to perform, and that contract is void for the other party also. Means when we start doing a contract, so there, that is a valid contract, but because of some reason it become nullified, or we cannot perform it, so we just give that thing term void contract. Next thing comes voidable contract. Voidable contract is a contract when one party is not going to agree and not going to perform a contract, or they said I am not going to perform this contract, or there is any missing part in a contract which in the starting both the parties agree, but when it's time to perform that contract, some party said that I'm not going to perform it, some certain condition, so it becomes voidable contract. Or I can say, if there is any key feature of a valid contract is not present in a contract, so it becomes a voidable contract. Means if I'm not if they I give a offer to the person, but he or she did not accept it, or it is unlawful, then I will consider it as a voidable contract. There is a difference also showing it to you about void contract and voidable contract. Same thing you can read out also. Next, our term is illegal or unlawful contract. If I just talked about these two terms, they explain by their name only. Illegal contract or unlawful contract. Illegal contract, unlawful contract are, if I talked about valid contract and if I just talked about contract, my first thing is that it has to be enforceable by law. If it is not enforceable by law, that means my contract is not a valid contract. That become what? Illegal or unlawful contract. That is known as illegal or unlawful contract. There are also a difference between void agreement and illegal agreement. Basically, void agreement and the difference between the void agreement and illegal agreement in a simple language is that void agreement can be performed when we done it. Okay, when we sign it, we are able to perform it, but when we are executing it, we are not able to perform it. That is void agreement. If I just talk about illegal agreement, we cannot perform it from the very first day. Okay, so there, that is the difference between void and illegal agreement. Then an unenforceable contract. Unenforceable contract is the opposite from the word which we are learning today. Unenforceable contract. It's a vice versa thing, like which we cannot be able to perform under the guidelines from our law. That is known as unenforceable contract. There can be a technical defect also, technological changes also, political changes also, economical changes also. Because of some changes, it cannot be happened because of law. That means we cannot able to perform. They give us a chart also for contract, which we read all the things. Like there is a first term which is contract. It is subdivided into three parts. Based first one is based on creation, second one is based on execution, third one is based on enforceability. Based on creation, subdivided into two parts: express and implied. What is express? When we can express ourselves oral or written, so that is a express contract. If we talk about implied contract is which you know you have to do it. which you are means nobody is saying it, nobody is writing it in any kind of document, but it is implied. Second thing is based on execution. Based on execution, executed contract, executory contract. Executed contract, what is executed contract? Which we are able to perform or we are performing. Okay. Executory, which we are gonna perform in future, that is executory. Executory is also subdivided into two parts: unilateral and bilateral. Unilateral contract is a contract when there is only a party who needs to perform the contract, other party already performed it, that is unilateral contract. Bilateral contract involves two parties are remaining to perform a certain contract, that is bilateral contract. Okay. Third one, heading R is based on enforceability. Enforceability, valid contract. There are four key elements for a valid contract: offer, acceptance, which become agreement. When agreement enforceable by law, that become valid contract. Void contract, which when we sign a contract, that is valid, but because of some reason it is not valid and we cannot perform it, that is void contract. Third one is voidable contract, which cannot be performed either by a party or because of unlawful act or any other reason from the very first day. Not when we are signing the contract, one of the party know that it's not going to be happen, but he or she, because of their interest, not telling to the other party, that is not going to be happen, that is called voidable contract. There are so many web series nowadays, and there are so many movies on these things that people contract, but they are not going to perform, they just took money and they just escaped from that thing. So for the other party who paid for the contract, that contract is voidable for their end. Next one is illegal contract, which is cannot be performed under the law, that is illegal, which that means our government prohibited that things, that is illegal. Unenforceable contract, unenforceable contracts which cannot be enforceable by law, that means our rules, our regulations told us that you are not going to perform these things, that is unenforceable contract. So this is the thing, this is our first unit which we cover in this. Sorry, there is one more topic in this unit: essentials of a valid contract, which I told you earlier also actually, but according to section we just read this out. Essentials of a valid contract. Valid contract, there are main elements I told you before: agreement, agreement which is enforceable by law, that is valid contract. If we talked about section 10, which covers essentials of a valid contract, they told us in this section is proper offer and its proper acceptance. Means somebody needs to offer something to somebody and somebody needs to accept that same thing on same condition, no other condition can be put on that thing, that is known as proper offer and its proper acceptance. Okay. Second thing is that intention to create legal relationship. That means if you are offer something to somebody, there is an intention of yours which is legal, which is if you are thinking something illegal, and if you are thinking that you are not going to perform this, you just took money and ran away, that is not a valid contract, that will be a voidable or unlawful contract. So if you want to do a contract, that means there has to be an intention to create legal relationship. Third thing, we just need to focus on that this thing, this is the first time we are gonna read this thing: free consent. What is free consent? uh, we know the word about consent, we know the meaning of this word consent. Means you just need to take permission, or you just need to know that other person also wants that thing or not. Both the parties who are into a contract, they has to be free from their mind, and they know each and every clause which is present in a contract. That is known as free consent. Means when they sign contract, they understood it, then they sign it. If they are not understanding that contract, that means they are not given you free consent. So both the parties, if they are giving free consent, then they are signing that contract, so it become valid contract. Next thing is capacity of parties to contract. Capacity of parties to contract means both the parties has that capacity to understand that contract. Means if I am doing business with 5-year-old kid and I am just telling him or her, means these are the clauses, you just need to understand this thing and you just need to follow these rules, that 5-year-old kid is not going to understand that things. So both the parties need to be stable and in that capacity to understand the things, the terms and condition which are present in that contract, so it become valid contract. Lawful consideration. We know consideration is a thing which we offer somebody in the exchange of something, like we are buying something, we pay for it, that is a consideration for that particular commodity. So lawful consideration means if I am selling something, like I am selling a house which cost rupees 1 crore rupees, according to that locality, according to that uh, carpet area, according to that luxury I am gonna give to the other person, which kind of a structure I made it. Means if it worth of that house is rupees 1 crore, that means that is a lawful consideration. If that worth is just only for 50 lakh and I'm asking for 1 crore, that is unlawful consideration. So I need to check it first that my consideration should be lawful according to terms and conditions. Next thing is lawful object. If I consider lawful object means what is my objective to do a contract. I need to basically, if I explain it to you, if I am doing a business with you, I am selling my product to you, my object is just to sell you a product, not anything else. Means my object, I am just selling it on a particular price which is according to its cost, it is okay including my profit. That is known as lawful object. Next one is agreement not expressly declared void, which I told you before that. What is, sorry, agreement not expressly declared void? Not expressly declared void means it can be performed in future. If it is there is any chances, I know that that thing is not going to happen, that I am not able to sign a contract. And if the other party know that thing is not going to happen, like I give you example of 1005 rupee, 500 rupee note, which are banned now, which are not with anybody now. I just contract with somebody with that notes, means that is a void contract, that is not going to be performed. So that means my motive is to be clear. My agreement or contract which I am doing has to be lawful, which I can perform in future and can make some profit also. Next one is certainty of meaning. Certainty of meaning means there is a chances, if I just said that thing, there is always a chance, 1% chance or 5% chances that it is not going to happen, because there are so many impossibilities in our world. Because of any reason, there is a certain chances that my contract is not going to fulfill. So I just need to check that first, that my contract is certain or it's uncertain. Next one is possibility of performance. I need to check that what kind of possibilities are present that I can perform my contract and I cannot perform my contract. If there is any possibility of non performing of my performance, that means that contract is not a valid contract. Next thing is legal formalities. Whatever legal formalities are present there, which I need to fulfill for my contract. So that legal formalities need to be fulfilled, and that legal formalities has to be done by my lawyer, my firm, or anyone whom I appointed to that thing. So these are the points for a valid contract. These valid contracts has to be these valid elements has to be fulfilled according to my contract. If my contract contains all these 10 elements, that means my contract is valid. And if my contract, there is any point is absent from my contract, that means my contract is not gonna be performed, and that is not valid, and that is just an agreement. And maybe it gonna be fulfilled or maybe it not gonna be fulfilled, but that is not a lawful contract. That just became agreement. That's why I, in the first thing I just told you, all contracts are agreement, but all agreement are not contract. That means agreement is a part of contract, but contract is not a part of agreement. Okay, is there any query?
Yes, madam. In fact, I want to ask you just a question regarding the first type of contract we saw, the express contract, in which we can have the format of a spoken contract. My question is that
Can you
how,
please mm, speak more
okay,
loudly?
okay. So my question is about the express contract. How can we follow up the spoken contract?
Basically, if I told you about the spoken contract, we live in a world where there is a word called trust. Okay, when we are doing a
Okay,
business, there is a so many things that we are not gonna write each and everything and document it each and everything. If I just told you that the whole business may be run on credit, I just purchased from my supplier, and I just told him that I'm gonna give you money when I just sell these things out and I just make profit, then I'll give you money. So that thing is gonna be on trust, basically. So
no,
if you are talking about oral contract, first thing, always remember that oral contract are only for short term. They cannot be for a long term thing. These are short term contract with limited amount. That means the consideration which we talked about, that consideration has to be with a small numbers, not in the larger number. So that thing can be considered into a oral contract.
okay. Thank you so much.
Okay, then we will start our second unit. Just give me a second. Is it visible to you? Screen?
Yes, ma'am. It's visible.
Yeah, it's visible.
So let's talk about our second unit. If I just told you about business law, so there are whatever terms we read in our first unit, there are whole chapters for it. Okay. So first thing we study offer and acceptance. Like I told you before, if I just talked about agreement, I just need to have two things. One is offer, one is acceptance. Offer, I need to offer something to somebody, and there is a certain party, Mr. A, B, XYZ, you can say, has to be there to accept that thing. If there is any party is not there, that means there will be no contract, there will be no agreement. So first we need to understand what is offer, what is acceptance. So they give us definition for an offer. What is an offer? They define this definition in section 2, subsection A. Okay. When one person signifies to another his willingness to do or to abstain from doing anything with a view to obtaining the assent of that other to such act or abstinence, he is said to make a proposal. Okay. यानी कि basically, sorry, basically what offer means to you, I just told you that I am giving offer to somebody. ठीक है. That means I am giving proposal to somebody. Here we use word proposal. Okay. Proposal means I just have an idea, any kind of idea, which I need to tell somebody that someone else is okay with that idea or need to perform agreement or contract with me on that idea or not. So first, I need to prepare a proposal or offer to somebody, what I am offering to someone, what I am proposing to someone. Like, uh, if there are so many marketing calls we receive each and every day, they already know what are they gonna offer to us. That means they are offering us, they are proposing us something. So in our business we just need to know what we are offering to somebody or what we are proposing to somebody. It has to be clear. If it is not clear, that means I cannot offer something to someone, or I cannot propose something to someone. And second thing, I just also need to know that somebody, some other person already wants that offer, already needs that proposal or not. It might be possible that someone, the person to whom I am offering, the person whom I am proposing something, he or she can be denied for that thing. My offer can be positive and can be negative in both the ways. For example, there are so many companies who are offering us life insurance contract. Okay, we just took that contract and we are giving them premium every time they ask for, and we are just uh, did a contract with them. But that contract, if I just asked from you, that contract is a negative contract, because we are contracting our life. That means which is negative. If we die, our legal hires, whoever they are, they always never wanted that thing. So that is a negative contract. So contract can be negative or contract can be positive. We just need to figure it out, what we are proposing to somebody, what we are offering to somebody, and they are okay with that, and if they are not okay with that, so we need to check that elements first, and after that we are able to offer or propose something to somebody. And it is also a very important thing that we cannot offer to myself. Means I if there is any idea, if there is any contract, that means that is not possible that I am offering it to myself. If I am offering it to myself, that means I'm not doing any kind of agreement or any kind of contract, because if there is a contract, it has to be two parties, it cannot be with a single party only. Okay, so for offer, first I need to know the willingness. Second, I just need another party to whom I can offer, to whom I can propose the thing. And there must be a factor that that person or that human understand what I am trying to offer. And that person who is making an offer, I can call him offerer, or I can call him promiser. Because if I am using the word proposal, so I use the word promiser, and if I use the word offer, then I use that word offerer. Okay, next thing is, how is an offer made? If I just talked about offer, these both the terms we discussed in the previous unit also. Express offer, implied offer. Okay, what is express offer? When I am expressing something to you, that is express offer. Okay, what is implied offer? Implied offer, it's like if I am traveling in a taxi, if I am traveling in a bus, if I am traveling in a train or a plane, so that means I need to buy a ticket. That is implied offer. Nobody is gonna tell me that you should has to buy a ticket for traveling in a plane or a train or a bus. I just know it very well that if I am traveling with any kind of transport, I need to pay for it. If I am purchasing something, I need to pay for it. Nobody told me about it. I am just habitual for that thing, because that thing is the culture nowadays. If I told you, if we talked about the tradition time when we survive with the barter system, that thing happen, give and take. Means uh, goods has to be exchanged. If I have wheat more, and if you have bread more, so we can exchange that thing. That is called barter system. But now we have a value, I can say that we have a money for that thing, so we use that thing to purchase anything, which is a implied offer. If I am going anywhere, if I am buying anything, I just need to pay for it. That is implied offer. Express offer, when I specially offering something to somebody, like I just need to sell my car, I just need to sell my house. That is what I can say, that I need to express. Nobody knows about it. So that is the difference between express offer or implied offer. Next is, to whom an offer is made. Means first I need to decide what I am going to offer to somebody. Second thing, I need to find that person who is interested in my offer. Like there are nowadays, if you know anything about business culture, there are different there is a trend for startups. lots of people are in favor of doing startups. They just have an idea, they just work on it, and they try to convince bigger firms, or I must say bigger financial institution, so that they can take funds from that company or that institution. So what they are offering their services to that, so that they will get money and they can start their business. So first I just need to know to whom I just need to make an offer. If I need to start a business and I am just going in a NGO to offer them that you just give me fund, but in the return they will ask me money, that it's a NGO, first you give us money, then we will do something. So I just need to specify a person or a group of person or any institution to whom I am offering made for what I am offering to somebody. That is the first thing I just need to do. First I need to specify in general that this person I am gonna offer my thing. Next term, if I just talked about legal rules for a valid offer. If I just, it's just like a valid contract, which we studied in the last chapter. Offer must intend to create legal relation. That means if I am offering something to you, that my intention has to be clear and it has to be legal. If it is legal, that means there will be no offer that will become unlawful. And the most important things, if we talk about today business, it has my offer has to be social welfare also, or I can say that for the welfare of my society. If you check now, businesses are doing so many corporate social responsibility. If you check ads today, they just told you that we are contributing this certain amount of money for this organization, for the poor people, to make them better. So we just follow that thing and we just go with that company. So they are offering us something, so we will go with them. So first I just need to create a legal relationship with the person to whom I'm gonna offer something. My intentions has to be clear that they are legal, not illegal. Second thing is terms of offer must be certain, definite, and not vague. Second thing is really very important. If I am offering to you that I am selling my car to you, okay, you ask me about money. I just told you random amount. You ask me anything else. I just told you random things, which are not the exact what my car is having. Okay, so that offer is not a valid offer. If I am offering something to you, whatever I am selling it to you, it has to be clear, it has to be certain with the definite terms and conditions, and there is no if and but are involved in it. Okay. Third thing is the offer must be distinguished from a mere declaration of intentions. If there is any kind of condition you just need to put, I just need to put in that offer. If you are offering something to somebody and you just need to basically, I must say, you just need to add some kind of conditions in it. So you, it's your choice, you just need to follow that condition, you just need to tell that condition to the acceptor. Then it's acceptor choice that he satisfied that condition or not, he will accept or not, but it's your duty to tell him. If there is any kind of conditions and terms you follow, if we check so many things, there are like example, I must say, we purchase things from online. Nowadays online terms may, there is a star, there is a statement terms and condition and there is a star. They just told us that they are offering certain goods to us in a very minimal price, like for rupees 500 or 600. Then they put a star on it. Then we just log in into their site. Then we just need to know that what prices are they charging, what terms and condition they are charging on us. That means they are fulfilling their duty, they are offering us, but they just told us about their terms and condition, and it's our choice that we are gonna choose that thing or we gonna deny that thing. That is our choice. Next point is offer must be distinguished from an invitation to offer. There is a two things in it. I am just uh, from the very beginning, I just use the word offer only. Now there is a term invitation to offer. Okay, means I am inviting someone just only for offer. Means I can invite different parties also. It might be specific, it might be non-specific. For example, if we talk about the stock exchange, sorry, not about the stock exchange, but we if we talk about the public limited company, okay, public limited company always issue their shares to the public. They are offering to a uncertain number of people, means there are n number of people they are offering their shares. Any person who is willing to buy that share, he or she can buy it. Okay, that means they, if you are not giving your offer to a specific person, so you invited them, so many person, they give you money, and it's now your choice to whom with whom you want to contract or with whom you don't want to contract. So you can invite also. Means if I am saying that I am gonna sell my house, but I am selling it uh, to the n number of people. I just put a board outside my house, and I just let out, I just write on a board, let out. There are so many people who just read that board, they can contact me, they can they just want that thing ki, that they are interested or not. That is called invitation to offer. So you have to uh, basically you have to clear that thing that you are offering to a particular person, or you are offering to the n number of persons. So there has to be a clear thing in that. Next thing is that offer must be communicated. Means I am thinking I want to sell something to you, okay, in a certain price, and I am just thinking it, I am not telling you, I am not communicating with you. So there will be no proposal, there will be no offer, because I am not communicating it. So it become offer when I communicate with you, because I want to sell it to you, I am not selling it to anyone else. So offer has to be communicated, and it must be communicated. If it is not communicated, then there will be no offer. Next is offer should not contain a term the non-compliance of which would amount to acceptance. Means I just made that kind of offer that nobody is gonna accept it because of some non-compliance. Non-compliance means I am not fulfilling all the rules and regulation which I has to be fulfilled. That means that offer is not valid for anyone. There is no person is gonna accept that offer. If I just want somebody to accept that thing, that means I just need to fulfill all the rules and regulation which I has to be fulfilled. Okay, so my offer should be without any non compliance. All the compliance has to be done. Next is special terms or condition in an offer must also be communicated. Like if I am selling, if I am selling a land to a certain person, and that one is 1,000 square feet land, and I just want that from that 1,000, certain certain land, I just must say that 50 square feet I just need to for my garage. Okay, 50 square foot. But I am not communicating it. This kind of condition. That's I am selling it to you, but I just need to use this place for my garage. Otherwise, all the other land is for you because he charged for it. If if somebody purchase my property, that means he owns that property. And if I just need anything from that property, first I need to told him before the contract, and if contract happened, then he can charge for me from me. Okay, so if there is any special kind of terms and condition involved in my offer, then it has to be communicated to the person to whom I am making a offer. Next thing is cross offer. What is cross offer? From the word, I can say when two people offer each other same thing with same amount with same terms and condition, that is known as cross offer. Okay? Means I am offering you that I am selling my car to you for rupees 10 lakh, and you are offering me that you want to buy my car for rupees 10 lakh. Okay, so that is known as cross offer, that the object is same, consideration is same, terms and condition is same, but on the same point of time two people are offering same thing to each other. That is known as cross offer. Next one is standing offer. Standing offer is an offer for a continuous nature. Means like I just told you, just make your mood. I am, for example, you are my best friend, and I just want to sell my thing to somebody, and I just said that I am selling it to you only. Whenever you are interested, just told me, and I am waiting for you. That is a standing offer. Means I am waiting for your acceptance, for your approval. I am very much clear that I am going to sell it to you, and you are the only person to whom I am going to sell it with this amount, with this quantity. But it's your choice, you when you are going to accept my offer. So that means offer is continuous for a unlimited time. That is standing offer. Because if we talk about offer and acceptance, it has to be in a certain time limit. If I just offer today, so there has to be a time limit for it. It may be expressed and it may not be expressed. If I got someone else for that offer, so maybe I accept, I just go to that person. But if I am waiting for you, then it has to be a certain limit. And if there is no certain time limit, then that offer will be considered as a standing offer. Is there any question?
From me, there's no question. Thank
Yes.
you.
Then next term is acceptance. We talked about offer. Now we talked about acceptance. If we offer something to somebody, then there has to be a party who need to accept it. And if you talk about the section for offer, there is a section called 2A, and for acceptance there is a section called 2B. In the fourth line you can see that section 2B, according to Indian Contract Act, you have to write this thing, a particular section, and with Indian Contract Act, because these sections are defined under this act only. No other act you can mention in it. If we talked about this section, and according to this act, act acceptance is when the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. A proposal, when accepted, becomes a promise. Means offerer and promiser. What they did, they offer us something, they propose us something. When we are agree on his terms and condition, and we just need to fulfill that thing, and we accepted that thing, then it become promise. That proposal becomes promise. Means I just need to sell something to you, you are agreeing with the all terms and condition, I just offered you that thing, you accepted it, then it becomes a promise. Now the question is, who can accept? First thing, to the person whom I just made the contract, that person can accept. Or if I just made a invitation to offer, then the person who is interested and who communicate his or her acceptance to me, that person will can accept that offer, or I can say promise. Next, how is an acceptance made? Acceptance can be made express or it can be implied. But acceptance, if I just talked about acceptance, 99% has to be expressed, not just implied. Because in if somebody offer me something and I am not communicating him that it is accepted from my end or not, he or she can go to some other person and offer that thing to someone else. So mostly, in the most of the cases, it has to be express acceptance. And if we talk about the offer, if offer is given in spoken words or in written, then I can communicate it my acceptance. But if offer is implied, so my uh, acceptance is also implied, it cannot be expressed. Like if I just like I just give you example of a public transport, that I just need to buy a ticket to travel from one place to another place, then I must say that thing that they are gonna give me a ticket for that thing. That is also a implied thing. I am paying for that particular seat, or I just need to reserve that thing. So they give me a receipt or they give me a particular ticket, so I can further travel from it. So that is implied contract. If I am paying something, so I'll get it from it. So these things are implied acceptance. Or when offer made into spoken words or in a written form, then my acceptance will also be in a spoken words or in a written form. Okay. Next is legal rules for a valid acceptance. In the above section, we just read out legal rules for a valid offer. Now we are gonna read legal rules for a valid acceptance. Acceptance must be absolute and unqualified. If I just talked about acceptance has to be absolute. Means somebody offer me something, so I have to be very clear that I'm gonna take it or I'm gonna reject it. These are the only two options I have, because somebody make offer already, they put their terms and condition in it. I just need to accept it or I just need to rejected. So acceptance, my acceptance will be in yes or no. If I am putting any kind of condition in it, that means I am further offering something else to the other party, to the offerer, I must say, then it become offer, it then it become counter offer actually, because somebody offer me something, then I added some conditions in it, then I offer him again, then now I am not acceptor, I become offerer. So if I just want to be acceptance party, then I have to be, my acceptance will must be absolute and unqualified. Next one is acceptance must be in a prescribed manner, which I told you before. If my offer is oral, I give my acceptance orally. If my offer written, I give my acceptance on a written basis. If my offer is implied, my acceptance is also implied. So um, it is basically what I get, then I'll return in the same way. Okay. Acceptance must be in a prescribed manner, and that prescribed manner is just there are three things only: express, sorry, oral, written, or implied. Or if I just talk about the elements, there are only two elements. One is uh, sorry, one is offer and one is acceptance. Next, third point is acceptance must be communicated, like I said it in the offer also, offer must be communicated. Then it is very important that acceptance is also communicated, because nobody is going to wait for anyone. If I'm not going to accept it, that means he will offer, he or she will offer that thing to somebody else. If I just talk about the acceptance, so I have to be communicated with that particular person who offered me that contract or agreement, or I can say that just an offer, because right now there is no agreement, there is no contract, there is just only an offer. So for that offer, I just need to communicate my acceptance to that person. Next thing, it acceptance must be communicated by a person who has the authority to accept it. Means if somebody offer you, so it's only your right that you will respond, that you will you have the only authority to accept it. Nobody else on your behalf can accept it. It will not be considered as a valid acceptance if somebody else will accept on your behalf. If somebody something is offered to you, that it is only your authority that you can accept it or you can reject it. Next is acceptance must be made within the time prescribed or within a reasonable time, which I told you before, that acceptance, there will always be a time bound things. Like if somebody offer you, there is also a certain time and there is also a certain limit for your acceptance. Somebody is waiting for you, that you are accepting his or her offer or not. And if you think that somebody is not communicating, that means you can offer it to someone else. It's not your duty that he accepted that thing or not, it's his or her duty to communicate with you, not yours. So if somebody giving you acceptance, then you can figure you can sorry, you can proceed it further. And if somebody not communicating it, so you can offer it to someone else. Next one is acceptance must be given before the offer lapses or is withdrawn. That means offer, if offer is finished, there is no relevant point to accept it. And if is offer is withdrawn, then there is no point to accept it. That's why there is a time limit. In that time limit, you need to accept it, and if you are not going to accept it, it will go on to somebody else. Like there are so many stores who are offering sale, but for a particular time. If you visit that store on that time, you will get the discount, you will avail that sale. and avail that discount, and if you are going after that time, that offer will be lapses or maybe will be withdrawn. So these are the points for your valid acceptance. Any question for that?
No, madam.
Next heading is communication of offer and acceptance. Communication of offer. Communication of offer, it covers under section 4 of the Indian Contract Act. If I just if I just talked about the communication, communication can be done by the various methods. It can be it can be from a telephone. It can be nowadays it can be on WhatsApp. Nowadays it can be on emails. Uh, if we talk about the traditional way, fax were available that time, or telegram will be available. That kind of telegram, not the app you are using nowadays. So basically, there is a time limit also. If we talk about traditional things, traditional time, it will take time to send that letters for the offer you are giving to somebody. It will take 2 days, 3 days, 4 days from a courier or some post offices you need to visit for that. But nowadays everything is on electronically, digitally, so it will not gonna take too much time for to offer something to somebody or somebody to respond to you. So if I just talk about the communication of offer, communication of offer has to be clear. If it is oral, then there will be no disturbance. If somebody said to you that there is a disturbance in a particular thing, or there is a voice break, or there is any issue, that means that communication is not proper, and that offer is not valid. But if each and everything is fine and your offer is communicated, so that is a valid communication for offer. Same thing is for acceptance. If we talk about acceptance, then acceptance can be given to the person on the same day, or taken some days, or just need to communicate that thing. And after that, it if you accepted that thing, so it become promise. If you deny that thing, then it will become offerer give offer to somebody else. It also covers under section 4 of the Indian Contract Act, and they told us the 2 points also. If we just read it out, communication of acceptance, point A is against the proposer when it is put in a course of transmission to him so as to be out of the power of the acceptor. Means you just communicated with that thing, but that happened in the traditional way. If you just sent a mail to the person, and if that person said it to you that he did not find that mail, or that mail undelivered, then there will be a problem. Otherwise nowadays it not that much a issue for that thing, according to the uh, basically our electronic media. But the main point is that acceptance must be communicated in a certain way, in a certain manner, so that offerer will get in touch. Next is contract over telephone or mobile. Nowadays, we are very habitual for telephone or mobiles, like we are just taking class and you are just taking lectures online, not on the offline classes. These all are digital. I must say, too much digital things happen. Contract over telephone and mobile is also a same thing, but that things consider in a oral offer and oral acceptance, because on telephone or mobile you cannot say that your offer or your acceptance is in return. But if it is from texting, then it can be but according to law we cannot consider that thing into a contract. But if something, some mishappening were happened, then you can file a case and then you can use that messages. But in general way, that thing considered as a oral contract or oral agreement or oral offer. If you just made on telephone or mobile, you just be sure that your offer communicated, your terms and conditions communicated to that person to whom you are offering, and that will be clear to him. And you can ask him that these things will be clear to you or not. If not, then you can communicate him again, or that acceptor is also need to be clear about his acceptance, otherwise it will become nullified. So your contracts over telephone or mobile, they all are considered as a oral contract or oral agreement instead of express, instead of written or implied. Next thing is revocation of offer and acceptance. Means I can withdraw my thing anytime. First, I just offer it. I have full power to remove it. If I give acceptance, I have full power to deny it, but under some conditions. What are these conditions? First thing is that revocation of offer. First, we must know about the revocation. Revocation is the thing taking back or withdrawing. We can say that is known as revocation. Revocation of offer comes under section 5 of the Indian Contract Act 1872. If any time when I just offered something to somebody, and he or she not accepted that offer till now, so it's my it's I can revoke it anytime before acceptance. If somebody accepted that thing, then there I just lose my power to revoke it or change it. Okay, so what is my time period to revoke my offer? Till when uh, acceptor not accepting that offer or rejecting that offer. If he or she rejected, so I can make new offer for that. But if he accepted and I need to change my offer, I cannot do that. I cannot revoke it, I cannot change it, I cannot put some terms and condition in it. And what's the matter for acceptance? Same the matter for acceptance. It also cover under section 5. Acceptance is the is also a thing when I accepted and I communicated it, and offerer know about my acceptance, then I just lose my part to deny it. But if my acceptance is not communicated, my acceptance is not known by the offerer, then I have full right to revoke it, remove it, or I can add any kind of terms and condition in it. So that is known as revocation of acceptance. Communication of revocation. I must say that thing. If I am revoking offer or if I am revoking acceptance, then it's my duty to communicate it to the offerer or to the acceptor. If I am the offerer, I am revoking it, then I communicate it to acceptor. If I am acceptor, then I am revoking it, then it's my duty to tell it to offerer that I am not gonna accept it. So communication of revocation is also necessary, just like the way I just I must say, I just told you about the communication of offer and acceptance. Same thing will gonna happen for the revocation. I just need to communicate. Each and everything has to be communicated in the same manner as they are offered or accepted, and it has to be communicated to the person who is offering me, and to the person who is accepting the thing. If I am offering to you, Means if I offered my agreement to you, my proposal to you, and you communicated to the third party that I'm not going to accept it, and you just think that you just told me that thing, but that is not going to happen. The person who is an authority who offered you, you have to be communicated with that person also, only, not to the any other party. That is also a important point to remember. Next is lapse of an offer. Means my offer is gonna lapse. On what terms and condition it's gonna lapse? First one is by lapse of stipulated or reasonable time. Means I just give 1 week to the person to communicate me whether he or she is gonna accept my offer or not, and he or she is not communicate me anything, that times lapses, that means that offer is also lapses. Means just like our most of the time when we go for a shopping, there are offers for us, they are for limited times. If we visit on these times, we get offers, and we if we visit after it, so we are not gonna means we are not gonna avail that offers. Next is very important point, need to know: by death or insanity of the offerer or the offeree before acceptance. Offeree word is used for the acceptor. I was using acceptor only, but the way for the person who is giving offer, we use two words: offerer and promiser. For the person who is gonna accept that proposal, yeah, we can use two words: offeree and acceptor. So according to this point, if offerer offers something to somebody and he or she will die, so it becomes necessary for their legal hires to fulfill that offer if that offer is accepted before his or her death. If that offer is accepted after his or her death, it depends on his or her legal hire, they are gonna fulfill it or not. But if the acceptor not known, not aware about his or her death, and he and she accept that contract, so his or her legal hires are bound to perform that contract. But in the case of acceptor, in the case of acceptance, it is not bound to the person or his or her legal hires in the case of death to perform that thing. Means it become vice versa according to our Indian Contract Act. Next is by failure to fulfill condition precedent to acceptance. Means if there is a condition, like I just somebody offered me something, and I just said that I'll accept it on this condition, and that person performed that contract or agreement, but he or she is not gonna perform that condition. So that agreement will become void, and that agreement will not gonna be performed or accepted, I must say. If that particular condition is gonna happen, then offer will be valid, otherwise not. Means if there is any certain condition are attached with the offer, that has to be fulfilled, and if that condition is not fulfilled, that is not gonna be happened. But you cannot attach any kind of condition after the acceptance made. You just has to be communicated before the acceptance. Next is by rejection of offer by the offeree. If my offer is rejected by the offeree, means acceptor, then that offer cannot be fulfilled. Next, if it is not accepted in a prescribed or usual mode, means I given a written document to that thing, and that is not I must say that written document has to be signed, but that document is not going to be signed by the acceptor, so that will not become a valid promise, that will just lapses. The next thing, by counter offer by the offeree, if the person to whom I just offered the thing, that person in a counter way offered me something else with certain terms and condition, that becomes counter offer, and that acceptance will become nullified. Seventh point is by revocation. Revocation means if I revoke from that thing, means I did not accept or I did not offer certain terms or condition, or I change it, or I just withdraw it. So that offer becomes nullified. Next is by subsequent illegality or destruction of subject matter, means the main essential part of that offer is absent or illegal. That time my offer or my acceptance is become nullified, and I am not gonna perform it or accept it. My acceptance becomes nullified if it is illegal, or the subject matter of that thing becomes voidable, or that means unlawful, basically, I must say. So these are the points for acceptance. So let's review the whole chapter. Is there any query?
Yes, madam. I have one question.
Uh,
In fact, we
a
discussed
little louder,
about the
please.
offer. Okay, so yeah, okay, I have one question. In fact, we discussed about the offer and the acceptance, and we discussed about the offerer and the offeree. And my question is that where is the place or the involvement of the third party, like the government of the authority, in the case of contract? If you take, for example, the case of implied offers. Thank you.
Means you want to know for the implied offers only.
I think for all is better.
Uh, Basically, when we are talking about the business, we are doing business with certain terms and condition which are told us by the acts, by the government, and each and every party who is involved of doing the business. Okay, then that business covers with contracts, and that contract subdivided into some things which we are studying, that is called offer and acceptance. Offer and acceptance are for two parties. That party can be anybody, means if I am doing a business, I can do business with any person who is fruitful for me, who is right for my business. I can offer my things to that person, but I just need to be clear that that person is under lawful things and is gonna perform all the offer and all the promises and agreements in a lawful manner, and that thing can be express written express or implied. Implied contracts are the contracts which we done basically with our government or with our public limited companies, like I give you example for the train tickets, bus tickets. Matlab, these are the implied things, or it's also an implied thing that if I just uh, go in a shop to buy something, then it's my duty to pay for it, because that is the exchange value nowadays. If I just talked about in a traditional time when barter system exists, then there has to be also a certain goods to exchange that thing. So it's an implied thing that if I am taking something, it's implied that I am going to give something, and nowadays we are exchanging money for the commodities. Now clear or not?
Yeah, it's clear. Thank you so much.
Okay. So basically, let's review our chapter. What we studied today, we studied about the offer, how offer made, to whom an offer is made, legal rules for a valid offer, cross offers, standing offers. Always remember that the cross offers are the offers when two parties are giving same offer to each other at the same time. But if two parties are giving offer uh, on the different times, that not become counter of cross offer. And next is a standing offer. Standings offers are very limited, and we are not gonna offer somebody that we are just waiting for you. They are basically just I can say that yeah, imaginary offers. But in a business world, these are not gonna use it on a certain way, because if I am doing a business, I just need to work, and I just need to gain profits instead of just waiting to somebody to accept my offer. So that is standing offers. You just need to know what is a standing offer. That's it. Acceptance. What is acceptance? Who can accept? How is an acceptance made? There are certain points which you need to read next time also. Legal rules for a valid acceptance, how to communicate offer, how to communicate acceptance, contacts over telephone, mobile, how you can revoke your offer, how you can revoke your acceptance, and especially one important thing which you gonna always remember, that it has to be communicated. You never discommunicated, or you never, if you not communicate anything to anybody, that will not considered as a acceptance, and that will not consider as a offer. If I have something in mind to offer somebody, so I had to communicate, and if I want to accept it, I had to communicate that thing also. And if I am revoking, I am thinking about withdrawn or revoking for it, so I need to basically, I must say, I need to communicate that thing also, because communication is the main thing. Maybe you have a subject also for a communication. Maybe I'm not sure about it, but if we just talked about our subject, business law, each and everything has to be communicated, whether it's oral, written, or implied. You just need to know that thing. Okay. Any other query to anybody? Is there any question?
No, there's no any question from the side.
Is there any issue of understanding according to my accent or anything else? Do you have any issue? You can communicate it to you to me.
No, there's no any issue. Everything is clear.
Okay, and it is your homework actually to read out both the units. And in the we are actually today we discussed block 1 unit block 1 unit 1 and unit 2. In the next lecture we are gonna study unit 3 and unit 4. So I just expect it to you, so you just overview, you just take a overview for it. Or at least if you are not gonna take overview for third and fourth unit, I'm there for you. But still you just need to read unit 1 and unit 2, and if there is any query for it, you can ask me in the next lecture.
Okay, ma.
Okay.
It's okay.
But
Okay.
yeah, but we have
Okay,
All
thank you
we
right.
so
have
Thank
much
you.
for
to
today.
Ibrahim.
Thank you so much. See you.